Hello and welcome. Today we are discussing the Canadian Constitutional Law for NCA exam. In this video, we will cover three important topics. One, what do you need to pass the NCA Canadian Constitutional Law exam? This is very important if you are taking your examination for the first time. But if you are giving your examination for the second time, third time, or you got a fourth chance, then I would urge you to look at this video till the very last because I'm talking about the approach that you need to have to pass this examination. Second, I'm talking about the syllabus in depth, and I will cover the important topics as well. I will make multiple videos to talk about each concept, but I will cover overall in this video to talk about the syllabus that you need to cover and how you need to approach it again. And the third thing is that I will talk about the resources that I've created that you can use during your examination, including the notes and the presentation to make things easy, along with the structure of the question that you can use. So I've created one skeleton that you can use during your examination to write exactly the way that the NCA would expect you to, have the answer in depth. So that's the skeleton that you can use. I have also created a list of case laws by the situation, so you will be able to read the question and will be able to point out, okay, I need to use that case law in this particular scenario. So I've written down the case laws in that format so that it is easy for you during your examination to pick from. Now these are the things. Before we move forward, you can actually download most of the things from my website. So basically this website is girilegal.ca, girilegal.ca. Here you see that you can actually book some time with me to, if you are giving your examination for the second, third time, or you have the last attempt, then you can reach out to me. I will help you strategize and correct your approach in passing the examination. I can help as much as I can. And then there are some NCA crash courses that I take specifically for the foundational courses, so you can book those as well. This one is interesting. We have specifically this mock exams for all the foundational courses. You can actually register for one of those, and one invigilator will be there to guide you through, just like they do in the real exam, and you will be able to prepare for the similar environment along with the questions of similar in nature. So you can actually book for those as well right before your examination if you want to feel more confident. So that's one. And then you see that there is the exam guide for the administrative law. You will have the exam guide for the constitutional law soon, right after this video. Now back to the video, right? So back to our subject. Okay. Now, as I said, like, what do you need to pass the examination, right? The approach. The first thing that you need to do is you need to really go through the syllabus. So, what is the syllabus, right? Like, if you have seen this page enough number of times, you will have some idea that that syllabus is not that huge. You know what? It's not really in depth as well. Like, they do not expect you to be expert of Canadian constitutional law. They want you to be have the understanding of the first or the second year or the third year law students, and that's exactly what they are going to check in the SC examinations. So they are not really asking you to do some really critical analysis on secession of Quebec law, the very first case law that you oversee over here, or understand all the deep meaning and the cases that are there for section 91 and 92. So that's something that they are not expecting. What they're expecting you to have is the basic understanding, the sources and the nature of constitutional law. That's the very first point over here, and that's the approach that I will talk about here. Now going forward, the second one is the amending procedure. So that's the basic concept, part one, right? So part two will be distribution of legislative powers. Then we have part three, which is Aboriginal rights and the Constitution, how they are intersected. And then the fourth one is the Canadian Charter of Rights and Freedoms. Remember this. This is again part of the Constitutional Law as well. And the last one is, if you these are like part 4, but then within part 4 we have two specific sections or headers, which are limitation of rights and then remedies. These are important, but again, I believe that these are more of a section 5 or part 5 of the course. So we need to approach this. Now, if you see that these are not really too many points to cover, so I think if you have about 30 days, you will be able to cover almost everything within 30 days if you are studying religiously. So my goal over here is that if you are looking at my video, I really want you to pass after looking at it. Like, I really wanted to have that understanding that you understood that what you require in order to pass the examination. So I'll try to help as much as possible. So now back to my point, right? So what I've done is I've created this whole presentation that you need to understand all the concepts that are important. And honestly, this is the meat of the matter. Like, this is where you will get most of the questions from. I'm not really claiming that I understand, and I'm not working for NCA. So I'm not claiming that these are the only questions, only topics where the questions could come from. But what I'm saying is that this is where the meat of the matter is. Like, these are important concepts that you need to understand. If you have the understanding of these concepts, and as I said, like, these are just 25, topics, areas of constitutional law that they're looking for. So it can't be that huge to start with, right? Like, so we just have to cover a really small set of area to begin with. And what I'm saying is that from that syllabus, I believe that these are the ones that are really important, because that's what the most important part is, right? So within my notes, I have created this PDF as well that again talks about the case laws, and then the basic concepts, just exactly the way that it is given into the syllabus. I have tried to answer that. Then I have also added like the case laws, as well as the as I said, like the structure, the skeleton for all the answers that you need to write during exam in IRAC format, so that you are able to really point towards the case law within the PDF, that okay, yeah, this is the one that I need to look into. And then you can reach to the skeleton and then start writing your answer in much more depth when you are using the skeleton to write your answer, because as I said, like, that is given in the IRAC format, so you will be able to use it like right off the shelf, right, and start writing it from there. So now let's go to the very first point to begin with. The very first point: sources and nature of constitutional law. Sounds interesting and sounds maybe too lengthy or boring at the same point of time, if you do not have the right material with you. But you know what they have just given one point over here. It says, go to Hawk chapter 1 sources and then read this one. That's it. So Hawk, if you're using the book, then that is perfectly fine. If you do not have the book, then what are the sources of the Canadian Constitutional Law? What I will do is I will click on this. Now this is the secession law, and what I will do is I will, give me a second, I will write, as I have already written, federal. As soon as I write federal, I am able to reach to a to the most important part of this case. I do not expect you to read everything. There are like paras after paras after paras after paras. If you have enough time, you can definitely read it, but there are more than 150 paras. So how do you know that where is the part where it talks about the sources of Canadian law, right? So, you know, I just clicked on the second time within the page. It is moving to the point where it talks about federalism, democracy, constitutionalism, and the rule of law and respect for minorities, right? So this is one of the sources of Canadian law which maybe is not written into the constitution. That's what it is talking about. So let me go back and go to the very first, um this one. Okay, so that's question one. The constitution is more than a written text, right? That's where the meat of the matter, this case law is, that the constitution is more than a written text. We know that the constitution is just not in written text, it is in the unwritten form as well. That's what it is conveying, right? So what we will do is we can actually go back and talk about that, what does it mean, right? What are the sources of Canadian law? So within the PDF, this is the part where we are talking about the sources of Canadian law. The very first source of the Canadian constitutional law is Constitution Act 1867, which talks about the division of power, as we have already read, division of power between the federal government and the provincial government and the federalism. If you remember, the word I typed in the case law was federal, because I wanted to really reach to that point where it is about federalism, or democracy, independence, or something of that sort. Then I was able to reach to that point right away. Not independence, but federalism, and where is it? Federalism, democracy, constitutionalism, and the rule of law, right? So we were able to reach to this point right away, and I'll tell you why it was important. So this Constitution Act 1867 talks about the division of powers between the provincial and the federal government. The second one is the Constitution Act 1982, talks about the Charter of Rights and amending formula. Charter of Rights, if you remember, Charter of Rights is somewhere in the part 4, talking about the Canadian Charter of Rights and Freedoms, right? So this is again part of our syllabus, right? Then the amending formula. Amending formula, if you again remember, is chapter 2 here, amending procedures. So again, so we are covering 1, but we are also talking about 2, right? So we will cover amending procedure in details, and I'll tell you how you need to work on it. Then this is one source of constitution. Now, if you see, this is the trunk, right? These are the written sources. You are able to see it, feel it, touch it, right? Then these are the unwritten sources, like these are buried under, and these are not easy to see, but they're also part of the constitutional law, that is constitutional conventions, that is integral rules of political practice, right? For example, uh, responsible government, and then political binding, not judicially enforceable. That's the unwritten rules and sources of Canadian constitutional law, right? It's not written anywhere, but it is part of, it is driven through the case law and became the part of the constitution over the number of years. Then we have the royal prerogative, that is coming from the crown. Now, crown of the England and the crown of the Canada is one of the same crowns, but then they are not exactly the same person. Like, I mean, even though the crown is the king, but then the crown of Canada should be considered as a different entity as the crown of UK, right? So that's the crown of UK, yeah. So that's second thing. Then we have the underlying principles. Underlying principles are like the reference resecession of Quebec. That's one of the case laws that we just read. Then we have federalism, democracy, constitutionalism, and the rule of law. If you remember, that's exactly what we saw here in this. So as I said, like as soon as I wrote federal, I was able to reach to the most important lines of this case. And that's exactly what it is talking about. Like, this is the unwritten principle, right? It's the unwritten constitution, which is not really part of the book, but it is still the part of the constitutional law of Canada. These are the only sources. You have to remember this, and then these are important for you to remember because when you are applying this to a certain situation, you should be able to reach to a conclusion. Even though there is no section within the Constitution Act 1982 or 1867, but this is part of the constitutional law of Canada based on the underlying principles of resecession of Quebec, because it talks about the federalism, because it talks about the democracy, because it talks about the rule of law, so on and so forth. So now you know why it is important. It is important to be able to support your answer. I'm going to talk about only in the terms of um, in the terms of the your exams. I'm not going to talk about in the terms of the actual real life scenarios, because that's not where we are today. We are only talking about like how do you need to see this for your exam. Okay, so if I am really too vague, I'm being vague specifically on the purpose, because I want to make sure that I'm not really going into a direction which is not required for you to pass the exam. So underlying principle, I think if you were not able to see before, now you can see on the right hand side that underlying principle is, they are given in the recession of Quebec case. So now going further, I'll go back and talk about what is the second part. The second part is here, that's not the part, the second chapter here is the amending procedure. How do you need to look at it? It's not really hard, but let's say Constitution Act 1982, Part 5, Section 38 to 249. Section 38 to 49. I'll click on it and I'll open this. I would actually ask you to open each of those links that are given and then go one by one. Like, if you see that I was able to cover the sources of Canadian law at least vaguely, superficially, very fast, but that's what you need right now. We will talk about in depth later on. That's all the understanding that you need right now for to understand the sources of Canadian law. Now for the amending procedure, right? Now this is section 38 to 49. Is it 49? Section 38 to 40, 38 to 49. That's correct. So section 38 to 49, these are the sections that you need to read within the section Constitution Act 1982, because Constitution Act 1982 talks about the amending procedure. Section 18 Canadian Constitution Act 1867 talks about the separation of powers between the federal and the provincial government. So now you know, right, these are the two separate constitution acts written in two different times, but they are working in sync and they have their specific purpose. So you have to remember 1982 is for a specific purpose, 1867 is for a specific purpose. You have to remember these few sections. So as I said, section 38 to 49. Let's go one by one and talk about what they actually mean. So second, again, this one, the amending formulas. The general procedure, section 38 is going to talk about the general procedures. What do you need to change the constitution um, through general procedure, right? Like that's the part one. So constitution amendment initiated, and then there are specific cases. Like if you need to change the language, right, then that should be through maybe unanimous consent. But then if you need to change the language, right, for a specific province, then that could be section 43, because it is talking about some provinces, right? So see this, yeah, I was correct. So language used within a specific province. If you want to make some changes regarding that, then you need to you need to apply section 43. But otherwise, if it is on the federal all province level, then it should be section 41, which is the unanimous consent, like everyone should agree. But for the general procedure, section 38 would suffice. What is section 38? 7 out of 50 rule. What does it mean? No, okay, my bad. 7 by 50 rule, not out of 50. 7 by 50 rule. What does it mean? Requires parliament plus 7 provinces representing 50% of the population, applies to most structural changes. So, you would need 7 provinces that represent 50% of the population, and the parliament's approval, and then you are basically good to go for the general procedure. Specifically for these one, like how do you know that these provinces are representing 50% of the population? So there is this calculation that is already there. I will share like what are the provinces and what are their populations. So that would require like Ontario, Quebec, and the British Columbia. There are some provinces that do not have that much weightage in terms of population. So we will have them by the weightage. So you will be able to see that, okay, is it covering 50% or not? That we can discuss later on. But for now, remember that 7 by 50 formula is like 7 provinces representing 50% of the population is for general procedures. Second one is the unanimous consent. But I'll go back to the Constitution Act and actually talk about it in specifics. Unanimous consent is section 41, requires parliament plus all 10 provinces, applies to the crown. Bilingualism, composition of the Supreme Court government are these two topics of few of them together to actually have the unanimous consent to make the changes. So if you did not get it yet, what it means is amendment by general procedure. Is it amendment by, was I reading section 41? Okay, I was reading section 41. Amendment by unanimous consent. An amendment to the Constitution of Canada in relation to the following matters may be made by a proclamation issued by the Governor General under the Great Seal of Canada only where authorized by resolution of the Senate, House of Commons, and the Legislative Assembly of each provinces. So what do you need? You need the Senate approval. You need the basically you need to pass this in the Senate. You need to pass the bill or in the House of Common, and then you need the all the legislative assemblies of each provinces, right, to basically have the unanimous consent. So what are those topics? The office of the Queen, the Governor, and the Lieutenant Governor of provinces. Now this is one topic where you need the unanimous consent. Interestingly, the composition of, no, not this one, an amendment to this part, as in, if you want to make changes to the section 41, you need the unanimous consent. Then only it will be possible for you to make the changes of the section 41 of the Constitution Act. Otherwise, you won't be able to make the changes. If you're able to make the changes here, that means you're able to make changes everywhere on the basis of the changes that are happening over here. So this is really important, right? So similarly, composition of Supreme Court of Canada, if you want to make changes there, you need to have a unanimous consent. If you want to make the changes on the use of the English or the French language, subject to section 43. If you remember, I was talking about for specific provinces, if it is only impacting, let's say, 2 of the provinces, then you do not need the unanimous consent. And I'll tell you why. Section 43. An amendment to the Constitution of Canada in relation to any provision that applies to one or more, but not all provinces, including any alteration to boundaries between provinces. I'd say, let's say 2 or more provinces, but not all provinces, then you need the amendment of provisions relating to some but not all provisions. And what do we need, right? I will talk about like what exactly you need, what kind of amendment you need there, or any amendment to any provision that relates to the use of English or French language within a province. If that's the case, then you need section 43 and not 41. So because you're only impacting some of the provinces, and there you would need the section 43 amending formula. And what is it? may be made by a proclamation issued by the Governor General under the Great Seal of Canada, which is exactly as Section 41, only where so authorized by resolution of the Senate, which is the upper house, and the House of Commons, which is the lower house, and of the Legislative Assembly of each province to which the amendment applies. So now you need the uh, you know the Senate, which is like, as I said, like you need the resolution from the Senate, from the House of Commons, and only from the provinces where the amendment applies. You do not need to go to all the provinces for the unanimous consent. So this is only for the you need the consent only from the provinces where the rule applies, where the changes are happening. So that's what it means. Sections, you just read through section 38 to 49 and you will be uh, covering all your amending procedures. And as I said, today we are covering on a very superficial basis, but this will actually lay down the foundation for you to be able to read further. Because if you do not really understand what does it mean, then I don't think you'll be able to go deep down. But I think you will be able to really, go to the Constitution Act 1982 during your exam and actually find which exactly is the case that applies in the scenario that is given to you at that point of time. For example, if a question says that the province of Ontario wants to make some changes and make let's say X language official language of the province, then what is the amendment procedure that is required? At that point of time, you know that this is specifically talking about only one province. It's not really going to impact all the provinces. Then obviously you do not need the consent from all the provinces. At that point of time, you can actually say that, okay, maybe this is section 43, and then you read over here and apply the rest of the facts of the case or the scenario that is given to you. At that point of time, you can just go and say that section 43 of the Constitution Act 1982 would be appropriate in this scenario. So now you understand, right? Like we just read these two and then we were able to really relate that what kind of question that could come, and you can apply the logic there on the basis of the facts of the scenario that is given to you. So let's go through this between section 38 to 49, and I guess most of the question that would come, because this is really important, right? Like it's not something which would not come. It's highly likely to have at least a question for 2 to 5, 10 marks maximum, but it won't be like something which is really in depth. So but it would be really nice to have like really quick 5, 10 marks during your exam without really struggling about it, right? So that's something one. So I've covered again like bilateral, some provinces, then federal alone. Like if it is specifically about parliament, then what are these? Then applies to federal executive, Senate, and House of Commons. Similarly, for provincial, you just have to go to legislature assembly, and apply to it. Similarly, let's talk about something else. Now, this is the federalism. Federalism is part of the Constitution unwritten principles, right? Like as I said, like if you remember, federalism is the unwritten principle of Canadian constitutional law. What does it say about it? Constitution Act 1867 talks about the section 91 to 95. This is actually talking about the powers of federal government. Federalism talks about what are the powers of the federal government. So, what are the powers of the federal government? These are the powers of the federal government which are given in the section 91, but it does say that from section 91 to 95, which is not true. As in, this is true, but then section 92 actually talks about the executive powers of the legislature, provincial legislature. But again, it's vice versa, right? Like it can be true that it actually separates the power of the federal government from the provincial government, which is, so provincial government powers are there in the section 92. Then we have 92A, let's say, but which one is, what is 93? So education legislation respecting education. In and for each province, the legislature may exclusively make laws in relation to education subject and according to the following provisions. So if you remember, there is a separation of power between the provinces and the federal government. Section 93 talks about education and gives the power to the provinces and not the federal government to make the rules and the laws about the education, right? So section 91, we'll go to section 91 and actually talk about it for a while. Okay, so now these are the head of powers: the public debt and property, regulation of trade and commerce, unemployment insurance, raising of money by and mode or system of taxation. System of taxation, you already know that these can be tricky, but this is again as part of the federal government. We'll see that like there can be an overlap sometimes as well. The borrowing of money on the public credit, postal services, and then the census and statistics. Military obviously cannot be uh, province cannot have their military or naval defense services or anything of that sort. Then we can have like navigation and shipping. All right, so you can read through the list: savings bank, weights and measurement, interest, legal tender, bankruptcy and insolvency, and then patent of innovation and discovery, copyrights, so on and so forth. Like you can all read over here that these are the 29 heads over here. And then any matter coming within the classes or subject enumerates in the section shall not be deemed to come within the class of matter of a local or private nature comprised in the enumeration of classes of subject by this act assigned exclusively to the legislature of the province. Okay, and I'll talk about something very important here. Section 91 talks about it shall be lawful for the queen, now king, by and with the advice and consent of the Senate and House of Commons to make laws for the peace, order, and good government of Canada. In relation to matter all not coming within these classes of subject by this act assigned exclusively to the legislature of provinces. Basically what it means is the important part was peace, order, and good governance. It's also called as POG powers, POGG powers, POGG powers, right? So if there is a head that is not covered within this act, like it's not here, any subject which is not here, any subject which is not here at all, that basically comes under the federal powers, specifically if it is about the one of the things, one of the concepts over here, which is peace, order, and good governance. So all the residual power actually lies with the federal government in that scenario. Now, federal government may choose to delegate this power to the provinces, but it basically lies with the federal government to begin with. And that's where, as I said, the important topic is, because if you think about it, if you get a question which is, let's say, about bankruptcy, right? So then you will be able to actually just point it out and say that, you know what, 91 section subsection 22 21 is about bankruptcy, so I know that the head of the power lies with the federal government. It's easy. I think it's hardly 2 3 point number question. But if they are giving you something which is like really dicey, somewhere in between, and you have to do the analysis, that's where the POC powers comes in. And that's where you will do the whole IRAC analysis, IRAC structure, your own analysis. You'll apply law and you will find out, try to find things that where does it lie. That's about 15 20 number question. So that's I believe is the important topic to begin with. So we'll talk about that in details. So as I said, if you remember, go back, and then the architecture here, the federalism. Federal powers here, I just covered few, and then provincial power here, then again, I just covered few over here. As I said, peace, order, and good government is basically that power which lies with the federal government and not the provincial governments. Okay, so how far are we in this video? 36 minutes. Okay. The federal residual power used to legislate on matters not exclusively assigned to the provinces. So any new matter, for example, something which has not thought to have a concept at the time in 1982 when the constitution was being written, is basically given to the federal government, which actually makes sense. Like something which is unknown should not go to 10 different authorities to make the decision on. Then it will be like really chaos for people of those provinces, that some provinces would enact laws related to their understanding, and some provinces can actually be really opposite to that. So in for the sake of consistency, it does make sense, to have all the residual power to lie with the federal government, and that's what exactly it is about. One of those power is the national emergency power. So if this is a national emergency, then basically that lies with the federal government, which does make sense. There cannot be 10 different provinces having their own national or like the provincial emergency power. So, but these power are temporary and specifically for urgent crisis. It's not something which for systematic occurrences that are happening over the time, and then you're calling it a national emergency, unless it is a national emergency and it is urgent in nature. And then parliament can temporarily invade provincial jurisdictions to address the emergency. So now you know that even if something is happening in Ontario, but that is of the national, uh, uh, you know, of national importance, at that point of time, federal government does have that kind of a power that it can. I wouldn't use the word invade specifically, but they can overtake the power of that uh, province for that temporary period of time, and address the national emergency in that particular province to begin with, and then they can get out of the province and give the power back to the provincial government as soon as the emergency not a you know is not a is not at play anymore. So that's the branch one. The branch two is the national concern doctrine. Now this again, like I'm not saying this is not as simple as the national emergency power, because in emergency power, the federal government takes over the the powers that the provincial government has, at least for time being, for that to address the crisis in that province or in that area, and then they get out of that province once the concern, the emergency is addressed, right? So that is very temporary in nature. So the provincial government do not have the power at that point of time to really, say that no, this is our area to address. So they can go to the court and challenge it, but then again, that's not something which will have too much of the substance to talk about. I mean, obviously everything can be challenged. Now, the two things that the federal government will have to prove is that is it temporary in nature? Are they really going to take like forever to address the national emergency? And the second thing is, do they have? Is it the urgent crisis? Like, is it happening right now, or is it like a systematic, progression of something which is, going down over the number of time, and possibly it won't be called as something urgent crisis, right? Like so those are the few things that the federal government would have to prove before calling it a national emergency, and taking over the power that the provincial government has. But again, as I said, like it's not as complicated as the national concern doctrine, at least in my opinion, because there it's the national consent doctrine is permanent in nature, like it's a permanent jurisdiction over matter of national dimensions. So if it's a national concern, the federal government will have the permanent jurisdiction over it. But then, in order to prove that this is the national, concern, this is a national concern, this matter is a national concern, they will have to prove certain things, right? What are those things? Those things are: one, they have to prove that the provinces alone are unable, they are not able to address the matter at the provincial level, and that's called the provincial inability test, right? If the provinces are able to address the matter at their level, that then that should be a provincial matter, that should not be a federal matter, right? But if they are not able to address the matter at their level, that should be a federal matter, and then that's what the federal government has to prove. At the same point of time, they have to prove the following things, like the singleness, distinctiveness, and so on and so forth. Once they prove this, this becomes the permanent power uh, and matter for the federal government to govern on, and that's the POG power, right? Like these are the residual power that comes from the section 91 of this act. So if we remember what I said, all the question that would come from, at least from the section 91, it will be very easy if they're going to give you, let's say, the bank, as I said, the bankruptcy situation in the question, because it will be very easy for you to just locate that this is bankruptcy in section 91, this is federal power, this is education in section 93, this is provincial power, so on and so forth. Like it's quite easy, right? I don't think they will give you the question for more than 2 marks or 3 marks for that kind of question. But if they are giving you a POG question where there is an overlap, it's more about a concept which has not been discussed before, or if it is a power which is the emergency power, that's where your analysis will be there, and you will be talking about, is the emergency justified under the POG powers, and then you will talk about the urgency of the nature. Is it temporary? Is it really going on for a long period of time? And then we can talk about it in depth over there. Similarly, for the national concern doctrine, that is it are provincial governments able to really handle the matter at their level? If yes, then it should be a provincial matter. If they're not, then it should be a POG power under branch 2 for the national concern doctrine, so on and so forth. But then that sounds like a 15-20 marks question instead. So I think we have covered enough. We have so much to cover, and we just covered hardly. We covered federalism. I think we are yet to cover judicial review and principle of interpretation, property and civil rights. We'll basically cover this in other videos. But so far, I think you understood. Like, you just have to go one by one, just like I was going, and then we already clicked on this one, right? So now we have to click on judicial review and principle of interpretation is there in the section 52 of the Constitution Act 1982, and then you have to read R.V. Morgan Taylor, then you have to read Canadian Western Bank v. Alberta. If you read these three, you are sorted for chapter 4, and that's exactly how you need to cover your constitution law. Now, if you see, just in half an hour, we were able to cover three chapters. You have enough knowledge, at least, to be able to point back to the material that where the answer is. You don't really have to remember all the powers under section 91 and 92. You just have to go back to section 91 and 92 and actually find where exactly that power is. You understand the basic concepts now. If you go on with the same pace and same approach, you will be able to cover most of this stuff here in this syllabus in next few days. And then I will specifically I will go into the depth later on by using either take the book, but if you are really lazy, or if you think that you are not able to get, because the book is really thick enough to go through all the subjects and you just have 30 days, I would actually start making my notes. I would say that, okay, this judicial power, judicial review and principle of interpretation is coming from section 52. What are the cases? The R.V. Morgan Taylor is one of the cases. I will read that case and then have my notes written about the the principle of interpretation, that what exactly was said in R.V. Morgan Taylor, and I will write that. And if I read a question that talks about the principle of interpretation, I will be able to actually write at that point of time specifically R.V. Morgan Taylor as my case law for that matter. So this is exactly how we need to approach. If you like the video, I can actually cover the rest of the syllabus for the constitutional law. I think I will cover most of it unless I don't think it will take hardly 2 more videos to cover most of it. So I'll make sure that I cover it the next time. So all right, so that thank you very much, and I'll see you again. Thank you. Bye.